In understanding the legal complaint that we have filed this morning, it's important to make one thing clear. This law serves no purpose other than to single out a small minority of people and to deprive them of critical protections that are available to all other family members. This law is wrong, it's discriminatory, and it's unconstitutional. We have filed our complaint in the Federal District Court for the Eastern District on behalf of gay and lesbian public employees and their partners, who are similarly situated to other public employees in that their employment is no less demanding and no less valuable. We believe that the Act violates their equal protection rights under the 14th Amendment, as well as interferes with their fundamental rights and protected liberty interests. The Public Employee Domestic Partner Restriction Act singles out gay and lesbian public employees by categorically denying them the ability to obtain health insurance benefits for their closest family members, their partners. There are exceptions to this law, but unlike heterosexual employees with domestic partners who can marry in order to continue their eligibility under the law, Michigan does not permit nor recognize the marriages of same-sex couples. Government employers remain free to offer these benefits to all other family members, uncles, parents, siblings, cousins. The only persons who cannot qualify for benefits under this law are same-sex domestic partners. It is clear from the statements made by the sponsors of this law that it was motivated by discriminatory animus towards gay and lesbian people. Sponsors of this bill clearly mischaracterized the current state of Michigan law regarding providing health insurance coverage for same-sex domestic partners and offered irresponsible and wildly inaccurate statements regarding cost savings. This law affects a relatively small number of gay and lesbian families, while at the same time expands health insurance coverage options for a wide variety of other family relations. Proponents of the law ignored the fact that public employees pay income taxes on the health insurance premiums for same-sex partners and often contribute to a percentage of the premiums out of their own paychecks. Sadly, both the governor and the legislature failed to take into account the economic advantages of providing health insurance coverage to domestic partners to attract and retain the best and brightest talent in Michigan, something that a majority of private businesses in Michigan and elsewhere have recognized. The sad fact is in addition to slamming the door shut to gay and lesbian families in Michigan, this law will not create a single job to benefit Michigan's economy. As Mike mentioned, a similar legal challenge was brought in Arizona, challenging their state statute, limiting health insurance benefits to married spouses of public employees. And that was struck down as violating the equal protection rights of gay and lesbian public employees and their partners. We believe that we have a strong legal argument that this law constitutes discriminatory public policy that cannot be supported constitutionally. And now I'd like to introduce some of our plaintiffs, families who will be harmed by this law. First, we'd like to introduce Peter Ways and his daughter, Eliza Brakey Ways.